have a little look. Yep, 30 participants, great. Hi everyone, I'm Electra. I'm the founder of the Law Boutique. And today we'll be talking to you about what Schrems 2 means in real life for in-house legal teams. I've got Antonia with me today, who is our data protection analyst.
Hi, nice to meet you all.
And then we've got Katie, who is our legal analyst.
Hi everyone, nice to meet you.
So just a few words about us before I jump straight in. So we are a legal optimization company and we support in-house legal teams predominantly with two things. So first of all, we help them set up their legal function in a really scalable, efficient, tech-enabled way. And we also help them with their overflow. A big part of our work is data protection because obviously it's a very heavy load for in-house legal teams, especially in fast growth tech environment. So when Schrems 2 came out, we thought, oh my God, COVID, Brexit, now Schrems 2, that's all we need. So we just wanted to provide you with some really pragmatic advice today, but also just to get a bit of background around Schrems 2 so that everyone understands what it actually means in practice, because I think this has just been happening over such a long period of time that things may have been lost. So we'll try and do that today. The way the session will go is that I'll start with a brief TLDR. Then Antonia will talk to us a bit about Max and why he bothered going through this. And then I'll talk a little bit about what you need to do next. And then Katie will talk us a little bit through the US surveillance laws and what they mean. And finally, we'll be giving you a toolkit so you can go away and implement this stuff afterwards. And we'll also be sending you a toolkit as well at the end, which will hopefully help you with implementing some of this work. As we go through the session, there's a Q&A section here. So feel free to add questions here. And at the end, we'll try and answer as many as possible, of course, if we have time. Okay, so, oops. So TLDR. So what does this decision do? So firstly, it tells us that the privacy shield is invalid. And what's more, transfers that rely on it are illegal. This decision affects all international transfers, so not just those to the US, unfortunately. So it is a big piece of work to sort this out. You can use these standard contractual clauses, binding corporate rules, or derogations from Article 49, but only if the laws in the third party country that you're sending the data to don't basically make these pointless. Each transfer needs to be assessed on a case-by-case basis to establish the grounds that you're relying on and that everything is fine. But if you can't establish that, you'll need to stop the transfer entirely. So we'll go through all this stuff in more detail throughout this session. Yeah, so let's jump straight in on how we got here.
So we're just going to have a quick look at this man called Max. So meet Max Schrems, a privacy activist who has successfully shaken up the way in which we all transfer personal data outside the EEA. Max Schrems' fight for privacy began way back in 2011 when he attended a university talk from a Facebook privacy lawyer in the US. He was so shocked at the lawyer's lack of knowledge on European privacy law that he submitted a data access request to Facebook. Schrems wanted to know what personal data Facebook held on him and what they were doing with it. Fast forward to 2015, and Schrems was beginning to make waves across Europe through his privacy activism. He submitted complaints about Facebook with the Irish Data Protection Authority and in his home, Vienna, Austria. The complaints really argued that Facebook didn't have the right to transfer personal data to the US. And Schrems' argument focused on the power the US government had and still has to interfere in data transfers through the PRISM mass surveillance program. Now, this program allows for the national security agencies to force internet companies like Google and Facebook to provide them with data about individuals. Well, in 2015, the European Court of Justice came out in agreement with Schrems. They declared that the Safe Harbor Agreement, the program that allowed for the transfer of data from the EEA to the US, to be invalid. And this judgment is known as Schrems 1. In 2016, in the wake of Schrems 1 and the inception of the infamous GDPR, the EU and the US authorities developed a new initiative that allowed for the transfer of personal data from the EEA to the US. And this is known as the EU-US Privacy Shield. But Schrems didn't see this new framework as any more secure than the last. The US government still had extensive ability to interfere in the transfers and impede on data subjects' freedom. With the backing of the new GDPR and his success in 2016, Schrems set in motion the inception of what we now call Schrems 2. On the 16th of July 2020, the European Court of Justice invalidated the Privacy Shield. They ruled that the programme does not provide adequate protection for data subjects' privacy. The Schrems 2 judgment was another landmark ruling for privacy rights, as well as a clear sign of the tension between EU and US privacy laws. As the Electronic Privacy Information Centre stated, the United States needs to reform its surveillance laws or risk losing its position as a global technology leader. The political tensions underlying this judgment may be marked, but as companies that handle personal data, we really need to look at the Schrems 2 judgment in a practical commercial manner, and that's what this webinar will focus on. Over to Electra, who's going to be discussing next steps and what this means in practice.
Yeah, cool. So there are three main questions we keep getting from our customers. So the first question is, should we wait and see or should we act now? So I'll address that first. Basically, when we had Safe Harbor invalidated, people did wait and see. The majority of people did wait and see. But now this affects more than just transfers to the US and more than just the Privacy Shield. It affects all international transfers outside the EEA. So this is a huge piece of work, and I don't want to underestimate how much effort this is going to require in-house legal teams to put into this. I would be advising to be looking at this as a standalone project of 2 to 3 months to get all the stuff implemented, and take into consideration the fact that we don't yet have enough guidance from the EDPB around what supplementary measures we need to introduce, which we'll talk about a little bit later. So we've got half-baked guidance at the moment, but we do know that there is a big piece of work that needs to be done in relation to basically collating all your contracts, making sure that they're in a place that you can quickly sift through them and then start doing the bigger work which is assessing. We'll go into that in more detail, but for now, to answer the question, should we wait and see or act now? Act now. Second question is, should we just stop sharing data with the US? Well, first of all, I don't know if that's possible. Businesses, especially in the fast growth tech sector, really rely on transfers to the US. And also, we don't think that right now you need to stop sending data to the US. Obviously, the guidance may be updated later on, but for now, we don't think that you need to stop sharing data with the US. And will there be a grace period? So the EDPB has said that there will be no grace period, which sounds really scary, but actually, realistically, we don't think that any enforcement will happen over the next 2 to 3 months. So, to Antonia's point before, we need to take a pragmatic and commercial approach, but I think so do the supervisory authorities, because we are already in quite uncertain times, and this just adds to it. So I think that there will be pragmatism there. Cool. So now Katie's just going to talk to us a little bit about what other companies are doing in real life, and then we'll talk about surveillance laws and why this all happened from that perspective as well.
So just to kind of give a baseline of what other companies are doing, at the moment, these are just a few companies who have already remediated their contracts and have removed the Privacy Shield and now include the SECs. So it's not a stretch to think that the data they're transferring to the US would be subject to surveillance laws, especially considering the volume of data that would entail. But they are definitely continuing with these transfers regardless of that risk. Having said that, though, this gives us a steer in terms of what the big players are doing and how they're tackling it, even though it's likely that the SECs alone might not cut it, and that the EDPB will provide more guidance as to what this means in practice. So moving on to the standard contractual clauses. So now that the Safe Harbor privacy principles and the Privacy Shield are considered illegal by the CJEU, the standard contractual clauses, or SCCs, are now taking the spotlight as the best option for a transfer mechanism. However, it's not always appropriate, as we'll kind of go into detail later on. If the surveillance laws in a country override the protections that are provided for in these SCCs, it effectively renders them pointless, and you'll need to find another way to secure your data transfers or stop the transfer entirely. So moving on to exactly what they are, this is what they are. They're not exactly the prettiest thing to look at, but they were written by the European Commission. However, it's important to note that they will most likely be releasing an updated version of these that will reflect the judgment of Schrems 2. So that version should replace any current SCCs in your agreements. These are meant to essentially be included in all data processing addendums to your master services agreements, T's and C's, whatever your main contract is that requires transferring personal data outside the EEA. And they also cannot be altered or negotiated in any way. So once they're in there, they're there to stay. Now, what do? They provide detailed instructions on the data transfer, such as what technical and security measures are in place for data protection, the roles and obligations of the data importers and exporters, what type of data is being processed, why, for how long, who will be sub-processing the data, and more details. So the overall issue with this is in relation to surveillance laws. And I want to quickly note that we'll just be discussing surveillance laws in the US, but as Electra mentioned, this does not just apply to the US. If you're transferring data to India or China, you'll need to assess the surveillance laws of those countries as well. So moving on to exactly what US surveillance laws are. This is a list, it's not exhaustive. This is just some of the surveillance laws in place in the US. Basically, you will have to, so with these surveillance laws, it essentially allows Congress and the executive branch or the president to essentially conduct a warrantless wiretap on any US citizen, either in the US or abroad, as well as any data on US soil. So a warrantless wiretap means that the Congress or president can essentially ask anybody in the government to spy on a person who falls into one of those two categories. So in the US, on US soil, or a US citizen abroad. They can do this for any reason, at any time, without the individual's knowledge and without having to get permission or answer to anyone. So it's a bit scary to realize what the government can do. So this is what, this kind of leads us to our thoughts about the whole Schrems decision and what this means. Just taking a step back and looking at the information we've covered, it's really clear just looking at that list of surveillance laws that no personal data can truly be protected if you're transferring it to the US. So this is why we're somewhat frustrated with the decision in Schrems and where we are at this moment. It's a step in the right direction because data exporters are now legally required to stop and think, is the data I'm transferring outside the EEA actually protected? But this assessment is really just a Band-Aid on an issue that requires a real overhaul of how data protection is handled in third-party countries, because in the US, everything can be subject to surveillance. So looking at it from Max Schrems' perspective, it can be argued that the combination of the SCCs and these surveillance laws assessments still isn't quite what Schrems has been fighting for, at least not until the CJEU comes out with more guidance as to when a line is actually crossed that should result in stopping the transfer of personal data. All right.
Yep, absolutely. So, all this work at the end of the day is Max Schrems getting what he really wanted. So what are the next steps for in-house legal teams, and how do we go about this minefield? So the way we're looking at it is that we're breaking it up into two phases. So treat this as a project. So phase one of the project, you can start immediately because you know what you need to do. And that won't change. The EDPB has given guidance in relation to that and has basically said, you need to look at all your agreements, all your transfers outside the EEA, and you need to put them all together and assess them. So the first step, collate, might sound like a simple step. We also appreciate that when you're in a fast growth environment, you don't always file your documents in the most tidy way. So this will be a big piece of work, which will be administrative, really. So all you need to do, or what you need to do, is get all the contracts together that under which you're transferring data. So you won't know this until you get all your contracts together. You might have a contract database. You might have a folder with all your contracts in there as PDFs, signed Word documents. That all needs to get sorted out. You might have a really good records of processing, which is great, but if it's not, and if there's a varying level of detail depending on the entry, that needs to be looked at. So collating all your documents together is the first thing. Putting them into some sort of database is the second thing. An Excel spreadsheet would do, or if you want something more sophisticated, let us know and we can show you what we've got. But effectively, that's that second bit. And then after you've put all your contracts together in your database, then you need to start reviewing them. And you need to be putting two piles of contracts together. One pile of contracts are the ones that rely on the Privacy Shield, and the other pile is the pile that rely on the SCCs. So then you need to be looking at the Privacy Shield ones and assessing the data that you're sending, because this is really important, right? Because if you're sending data, I don't know, financial data, for example, that might be subject to different laws than if you're just sending technical data outside the EEA. So you need to be assessing the type of data that you're doing, that you're sending, and then the local laws in the jurisdiction that you're sending it to get a comparison between those laws there and how they compare to the protections afforded by EU law, by the GDPR. So that's a big piece of work that you can start doing straight away. What we've done to help out, and we'll send this to you after this webinar, is we've put together a transfer impact assessment form. So this looks like a DPIA, basically, but it assesses your transfer. So we'll send this over, and this is the bit, the bit in the middle that we talked about earlier, the review bit. This review bit is basically making sure that you've got your contracts in place so that you can do your assessment subject to the transfer impact assessment form here. So if you look at a few of the questions, they're a little bit open-ended because it is a black and white kind of assessment. Like all assessments, it is taking a risk-based approach and also understanding what data you're sending and how they're affected by the laws in the jurisdiction that you're sending it to. So once that big piece of work is done, we go into phase 2. Now, obviously, we don't know what phase 2 is going to look like because we don't have the guidance from the EDPB in relation to supplementary measures. So what are those supplementary measures going to be? It looks like it might be something along the lines of, right, every time you send data outside the EEA under the SCCs, you're going to need to make sure that the data that you're sending is encrypted or anonymized or sent with this special security measure. We're not quite sure what that's going to be, but it looks like this might be a job for your tech team as well. Not only for your tech team, it depends also if you're a controller or processor, because if you're a processor, you want to get on top of this immediately because this could cost you business, right? If you can't assure your customers that the data that you're taking from them is being treated in the right way, it's going to be problematic. So if you're a processor, you need to start thinking about how you're going to tackle this and maybe take a steer from what the other companies do, like Facebook and Google. I don't know if you got an email from Google saying now the SCCs will apply. We did, because we use Google. So you'll see that they're already acting. So once you know what contracts you need to remediate, you will remediate them, and then you may need to put together your supplementary measures subject to the advice that we get from the EDPB. And then, of course, you need to start thinking about how you're going to monitor these laws. What if this law changes now, and now this data is subject to different surveillance, for example? So this is something to think about. Again, it would be great if the EDPB could give us some more guidance so that we can start scoping out how much work this is actually going to be and who in the organization needs to help us. So as I said earlier, if you're a processor, this is something that your tech team will need to treat as a project too. So it's not just the legal team. And of course, don't forget that everything that you do needs to be documented. So your records of processing should now become your Bible, because whatever you're doing, your contract database, everything that you're collecting, all the information that you're putting together, putting your records of processing, this is a great opportunity to get your house in order. Obviously, everyone, not everyone's got the luxury of time to be getting their house in order. But now that we have to, we should be looking at this as an opportunity to do that. And what about Brexit? Yeah. So, Katie, do you want to talk to us a bit about Brexit and how this will apply?
Sure. So Yeah, no webinar would be complete without a shout out to Brexit. So we just want to quickly point out with you all that the work now required under Schrems also presents a really good opportunity to start thinking about what happens in the event that the UK is not afforded an adequacy decision when it departs from the EU. This judgment will most likely have to be considered as the UK seeks to negotiate its own adequacy decision with the EU to apply from the expiry of the Brexit transition period. So if you think you'll be able to get out of this exercise because of Brexit, think again. It's going to still need to be done.
Yeah, it still needs to be done. And it's also just a great primer for when Brexit hits, because we don't know what the decision is going to be, and we're going to need to review all our agreements anyway. I also just want to acknowledge that we didn't really talk about the Article 49 derogations, because we don't think they'll be the most commonly used measures that companies that we're addressing at the moment will be putting into place. And we also didn't talk about BCRs in detail, because they're really expensive to put together, a very lengthy process to go through. Not many people have them, not many companies have them. So we haven't addressed those because we don't think they'll be the most commonly used measures that tech companies in a fast growth environment will use. So yeah, grind now, shine later. So I think the moral of the story is this is going to be a lot of work. Don't wait before you act, and start working on it now. And we will be sending the chance for impact assessment after this webinar, and we'll also be sending just a flow chart that says if it's this, then that, which we haven't got for this presentation because it didn't look very good, but we will be sending that over afterwards. So if you have any questions about any of the stuff that we've spoken about, please drop us a line. So yeah, have we got any questions from the audience?
We have one, and it says, thoughts on Privacy Shield 2?
Yes, thoughts on Privacy Shield 2. Potentially, I mean, Max Schrems is going to have a burnout if that happens. So I don't know whether that's a potential, but it could be. I think if the US is going to take a pragmatic approach to this and realize the potential commercial impact, they will need to come up with something. And I don't know whether that's Privacy Shield 2, that's a potential, but again, I wouldn't hold my breath at this stage after everything that's happened and the impact of this decision.
So next question, do you think a post-Brexit adequacy decision is realistic / attainable?
Yes, definitely. I think it is it's a political game, isn't it? If we want to be put on the naughty step for what we've done, then this is a great way to do that, I think. And I think look, at the end of the day, the UK was instrumental in the drafting of the GDPR. We really drove this regulation. So it's a bit rich to say that it's not an adequate country. So if they do say that, it will be this making an example out of us. If that happens, then all this work that you're doing now will lend itself really well to that. Oh my God, I'm hoping that doesn't happen and that we do get that.
Okay, so I've got another question. What other security measures could be contemplated?
Security measures, yeah. So encryption is an obvious security measure that you should have in place anyway. But when you're sending data abroad, outside the EEA, we should be looking at pseudonymization and, if possible, anonymization. Now, I know that the ICO are actually putting some guidance together around what anonymization means, because the 2012 paper that they currently have on their website is outdated. It's really useful and it's very well written. So I'm hoping that it won't be too different to that paper when it comes out again. But effectively, it would be great to understand what anonymization actually means under the GDPR so that we can take the right, to actually apply it. We're working with a blockchain company now at the moment. And when they hash their data, to unhash that data, it takes 10 million years. So in real life, is that not anonymous data if they don't have the raw personal data? Arguably, yes. But ultimately, the EU has said that any data that's pseudonymized, that's hashed in a blockchain scenario is is only pseudonymization and not anonymization. So I don't think the 2012 guidance at the moment is sufficient for us to take those security measures that we need to take. Because if we were able to put some really good security measures in place to transfer that data, that would be a great solution.
Just following on for that, someone's asked if we should consider putting in supplementary measures before the EDPB actually issues their guidance, or should we wait until they've done that?
Well, I think we've got enough to be getting on with before we even get the supplementary guidance, to be honest. I would start off quite methodically with this. I would start off by putting your contracts in one place, getting all the information out of the contracts and listing it, seeing which contracts rely on the Privacy Shield, seeing which contracts rely on the SCCs, and then assessing the data, then assessing the laws in the country to see how that data is affected. That's a big piece of work on its own. And what you don't want to do is waste any effort. So I would advise no at this stage. Start with this and then wait for some more guidance, which will hopefully be imminent.
Okay, we've got a couple more questions. I'll just pick some out. One good one is, should we be updating our US privacy policies as well?
Yes, very good question. And I'm sorry that we didn't address that. That's a really good point. We need to be talking about our privacy policies. We don't know exactly what the update will be, but we need to start looking at how we basically give the people that are reading the privacy policy the transparency that they need to have in terms of how you're transferring the data. So once you've agreed on, like, for example, we're going to apply the SCCs and we've done this assessment, it's all fine, you need to tell them that you're going to be doing that, because most privacy policies now will mention the Privacy Shield. So all that stuff needs to come out. So yeah, another one to add to the list in terms of stuff to do. But as I said, I don't think there'll be any enforcement for the next 2 to 3 months, to be honest. I don't think the ICO is going to come down hard on anyone who's not implemented everything right now. So that's probably one for a little bit later on down the line, when you know what you've done and you can actually update your privacy policy accurately.
Okay, another question is about Brexit again, fun times. And it's, in the event that there is a no-deal Brexit, should people be putting SCCs in place for UK companies processing data with Europe as well?
Well, that was the debate, right? Actually, people were saying, can't we just rely on the Privacy Shield if we get a no-deal Brexit and we don't have an adequacy decision? And there was a question around that and people were debating that. That's out of the window now. So yes, it will have to be subject to the SCCs. Any transfer from the UK to, say, Germany will have to be subject to the SCCs if we are not an adequate country for the purposes of GDPR.
Okay, and then another great question is, do you think that the ICO will remain lenient for large businesses due to COVID in light of all of this?
I don't know. I hope so. I mean, if you're a big business, this is an even bigger problem, right? So you need to give people the time. What you don't want to do is scare people so they rush into doing something. They don't do it properly. They don't do their assessments properly. And then they've got to do another big piece of work to remediate the not great piece of work they did initially. So I don't think that without clear guidance from the ICO or the EDPB, that they can be very harsh at this point in time.
Okay, and lastly, we have a question that says, do you think it's realistic that all companies will actually encrypt their data to the US if that turns out to be a valid measure? Because the EDPB has always been on the fence around those requirements.
Yeah. I don't know. I think we need to wait for the supplementary measures to be clarified and for them to actually address the things that they've been quite grey on to date. Because you're right, we haven't had great guidance when it comes to these measures that are expected from a technical perspective. And it feels like they're making up the laws, you know, they're devising these laws, but not really talking to the tech community properly. So there's this silo going on. So you've got cutting edge technology being developed, and you've got these guys building laws that aren't fit for purpose. So even when the GDPR came out, it was already outdated because it didn't really address the stuff that's relevant to today's tech businesses. And that's what we find challenging now, right? We're trying to advise on things like machine learning, and we're looking at the data that's being fed into it. And we're like, oh, we're not quite sure how this works because we haven't had guidance until very recently when the ICO actually gave guidance on machine learning. When that came out, it was amazing because now we know how to advise. So this is also a great opportunity for the legislators to actually address the stuff that has been grey, and hopefully that will happen But I think that, you know, it is realistic to expect that companies will have to take some sort of tech measure when they transfer the data outside of the EEA, because otherwise they will be hindering their own commercial feasibility. So yes.
Okay, and one question for you, Katie, about surveillance laws. Someone's asked if there's a resource you can recommend that outlines the application and scope of all these laws, which I imagine would help with assessing them when that time comes.
Yeah, honestly, I am not aware of, you know, a really succinct list that has all of the U.S. surveillance laws. It's, I think one of the biggest issues with that is it is a mix of not only articles of the U.S. Constitution, but various case law and various acts that go back from the 1970s. So it's kind of a wide range of laws that you will need to kind of pick through to determine what is a surveillance law. I would recommend maybe speaking to an attorney in the U.S. who, you know, specializes in that, because they would know exactly what would apply to your data transfer, because there are so many. So it's difficult to have that really short list. I actually also saw another question about who prosecutes the U.S. government if they still commit a warrantless wiretap despite companies having the SECs. Essentially, these surveillance laws trump what's in the SECs. It's a very gray area right now, but they can legally conduct these warrantless wiretaps. There are a lot of NGOs in the U.S. that are continuing this fight for better data protection for U.S. citizens. It's an ongoing struggle. A fun weekend thing for you to do is to watch the movie Snowden. I'm not sure if you're familiar with it. I highly recommend it. It's a really good look at just how far the U.S. government can go sometimes with these warrantless wiretaps. So definitely look into that, and you can kind of see the extent of this.
Cool. I think we've got.
Movie.
Yeah, it's a good movie. I don't think we've got any more questions. So yeah.
Great. Okay, well, we'll give everyone a bit of time back then. If anyone's got any other questions or anything like that, please feel free to email us. As I said earlier, we'll be sending over the transfer impact assessment. We'll also be sending you a flow chart on how to assess certain things, if this, then that. Yeah, I don't know if we recorded this. We may have recorded it, so we will also send that over if we have. I think we have. So yeah, thank you all for joining on this disgusting day, and really appreciate your time. Take care.
Bye.
Bye.